Hi everyone, welcome to the Introduction to Module 5 of Introduction to Law, and this week we're looking at precedents as the second of our major sources of law and legal authority. So we're up to week 5 of 12, which is pretty frightening how quickly that's rolled around, but we're starting to build that knowledge layer on layer on layer each week as to how you use law and how you make the different parts of law work with each other. So this week we're following up on last week's, which we focused on rules, and rules being a reasonably straightforward set of written rules, from informal through formal, that need to be followed. Of course, in law, rules take the forms of legislation, sometimes legal principles under common law. And this week we're looking at at the situation of what happens when you need discretion. Well, there's a situation where someone needs to make a decision, and this is where precedents come into play, and this is where law often needs wiggle room to be applied in a way that's fair and just, particularly in situations you couldn't foresee happening when original laws were written. Now, sometimes that can happen, sometimes it can't happen. It depends on the way those original rules are written. And under the common law system, there's really two main ways in which this discretion comes into play, because judges don't have a total discretion. If the law says this plainly under the rules, there's no discretion. But there's two ways in which this discretion can come into play. The first is where there's ambiguity in the rules or the way the rules apply, and this arises quite naturally. And it happens particularly over time as new situations arise, or new technologies, or new combinations, and there are simply things that you didn't foresee happening, and that's when a judge is called in to say, how does this apply in this circumstance? The other way this ambiguity can happen is where the legal principles deliberately leave wiggle room in place, and they use words which some would call weasel words, a little nicer and call them wiggle words, I guess, like reasonable, or such as a reasonable person would think, that allow a later person to look at it, a later person who's making a judgment, to look at it and go, okay, what a reasonable person would do in this circumstance is this. There are other things, something that's dangerous, something that's harmful. There's a lot of words that law uses that have no absolute objective fixed meaning, that later on gives them the ability to define them further through common law, and to say, in this circumstance we think this is reasonable, this circumstance we think this is unreasonable. And each of those precedents, each of those decisions stacks up and starts creating this almost like a database of knowledge as to the way in which the law works and the way in which it operates. So that's pretty distinctive to our system of law, to the common law system. Most other systems are very much focused on the rules themselves. And this is a situation, I guess, where what's fair depends on what you think fair is. Our system was really informed by the idea that fairness is really all about being able to make strong rules pronouncements, but give them a little bit of wiggle when you come to apply them in some circumstances. But in plenty of other people would say that our rules are vague or weak, because we keep putting these things like, the standard is what a reasonable person would think, and that is meaningless. The rejoinder, I guess, from the common law theorist is that they're not meaningless. You just then have to go to the common law and read all of the common law to find out what the meanings of those are. So it's an interesting approach. It's a tradition that has a lot to do with the relationship a judge has with posterity. When a judge is delivering a decision, they're not just delivering a decision for the parties before them, they're delivering a decision for the future, for their colleagues, for other judges, for other lawyers, and they're saying, in the future, this is how I see this principle developing. And the entire law is actually based, the technical term is hermeneutics, but it's divinity studies, because a lot of before law was a university degree, most lawyers had sort of classical liberal educations, and a big part of that back in the day was divinity studies. So the way in which a judge approaches or a traditional judge approaches the interpretation of the legal text is much like a biblical scholar would apply when analysing the word in the Bible and what the Bible means and how the Bible applies. And of course there's equivalent systems of thought with the Talmud and the Quran. So it can be quite frustrating for people who come into law now with a modern mindset, that you read these old cases and the approach they take is not necessarily what you would think that a modern scientific jurist would take in finding the answer. The cases are often fairly meandering, and a part of that is because the old cases were all just orally spoken. The judge never wrote them down, and they would just sit there and talk away, and some poor person would have to write down everything they do. But it's also part of the nature of the way they approach things, that there's this big conversation going on, and there's no real need to get down to dot points and really focus in on what the law actually means. So as a social institution, this made the common law very flexible, very able to adapt. It basically produces memes, not in the internet meme sense, but in the terms that it creates these evolutionary ideas where these different concepts and ideas compete with each other through survival of the fittest, to see which principles will become accepted later on in law and which ones will be rejected. But it has meant that law is more inaccessible. And as time goes on, laws become more and more complicated, more and more inaccessible, and more difficult for an average person to understand. And every so often, of course, we codify the law and we bring it back to, here's a new piece of legislation, consolidates everything into the legislation, but then, of course, the cases start coming out and we start moving away from that solid, fixed understanding. Okay. So important tools to take with you this week, and these are things that are going to come and we're going to explore in the workshop, is the difference between the ratio decidendi and the obiter dicta of a judgment. And that is that the ratio is the binding part of it, the obiter is the persuasive, or not so persuasive, but the part of it that's not binding. And the actual dividing line between those things is not always clear, and part of the skill nature of legal argument is being able to argue where that line falls, and being able to say and convince a judge in another case that yours is the correct interpretation. So, and I think I've given this example before. If you've got the Dog Act, and the Dog Act is very vaguely defined and says it applies to all four-legged animals, and someone takes their platypus for a walk without a license, and the dog catcher says you have to pay a fine because your platypus is unlicensed. The question is, does the statement that the four-legged animals, does that apply to all four-legged animals, or is that constrained by the fact this is the Dog Act and it's only really applying to dogs? And there's sort of arguments all along the line, and there's not a decision will have to be made on a case-by-case basis. So there might be a situation where you've got different types of dog and whether they're included, and you end up with this categorization process that goes in and out. So the ratio is what counts as a dog, and what doesn't count. Now, what the obiter component of this is the everything else that's said on the side, where the judge might say, well, in this case, it clearly doesn't apply to platypuses, but if a case involving goats came up, well, the Dog Act might apply to goats. Future, there's a legal reason, some strange legal reason why I think it might apply to goats. It's not necessary to decide in this particular case, but I might make a different decision in the future. So what you're doing, and we call this distinguishing a case, is we distinguish between the stuff that we're saying is binding and the stuff we say isn't binding. And our opponent will probably draw a different line there. Because you can be very pedantic and you can say, well, the Dog Act, I think it only applies to Alsatians and it doesn't apply to Chihuahuas. And you can make an argument that those are different things. And you can make an argument on the basis of distinguishing a case. The original case was only about Alsatians, didn't apply to Chihuahuas, therefore it doesn't apply to Chihuahuas. Now that would probably be considered too narrow in a definition of a dog, but that's an example of taking it in the other direction and splitting hairs in the other way. So the process of distinguishing cases is having a look at the cases that agree with you on one hand, the cases that disagree with you on the other, and then finding the principles that come out of them. And you use that process of drawing that line between ratio and obiter to find your argument as to where, you know, that the case includes your point, but not too wide as to be too general. Anyway, so we talk about stare decisis in the notes for this week, obiter dicta ratio decidendi. The challenge for this week follows up on this, and as we have been doing with the challenges so far, it's just a very simplified, stripped down version of the idea of a hierarchy, following hierarchies, and being able to distinguish between what's a broad statement and what's a narrow statement. And it's pretty much reduced to a puzzle. Pretty much what I've done with that particular challenge is taken out all the argument about what's right and what's fair and what's just and all those sorts of things, and just reducing a thing to a semantic puzzle where you're just trying to figure out which court has the authority to say which and how broad those statements are. So we will put these together starting next week, and we'll start assembling the tools we've developed so far, critical thinking, analysis of rules, analysis of precedents, into a more legalistic context, and we'll start looking at how all those things work together. And then the week after, we'll be looking at an example problem as you'll be doing your problem solving exercise. So that will bring all the pieces together and assemble them into something that looks more like a contemporary legal argument. Anyway, it's Easter coming up. Hope you have a good break if you're able. It does mean that this week I haven't been able to really discuss the feedback from your check-ins from this week, because I only just sent them out an hour or so ago. But I'll catch up on those next time. I thought it was more important to have this video out there before the weekend so you don't get it too late. So apart from that, I will talk to you in class next week.